Guess what? No attorney is going to do this for you. Hi, I'm Meg with Stand With Meg. I want to give you a little advice that I've learned that I've been helping people close to me to also find out for themselves. Go and look at all your cases in your state, the appellate court and the Supreme Court, and go find cases that represent or can help your situation. For instance, you can search your judge or your GAL. I'm going to show you something I found today that's pretty amazing. All right, let's read this. So this story was about a mother had a child within DCF or CPS. They appointed her a attorney because it was a child in need of care. So of course they give you attorneys there in that type of court. But I'm going to tell you, this is true and solid evidence. These attorneys do not care about the best interest of the children or their client. This mother went through 4 or 5 attorneys, and I can put this case on my website so you can see it. But in this case, this mother was begging these attorneys to fight for her child's right, and they kept saying nope, and they kept withdrawing. And that's what happens. Just last week, one of my personal friends that I kept telling her to let her attorney go bailed on her, just withdrew. Actually, I have 4 friends right now that just had their attorney withdraw from them. So here's what you have to figure out. And I'm going to read a part of this case where this case is pretty amazing because then the appellate courts ruled in the mother's favor, stating that she did not have due process of rights before her child was taken. So over 100 years ago, the Supreme Court ruled Mayer versus Nebraska, and it was in 1923, held that the liberty protected by the Due Process Clause indicates the right of parents to establish a home and bring up children and to control the education of their own. And in 1925, the United States Supreme Court recognized a parent's constitutional right to direct the upbringing and education of their children under their control. This was just published in 2024 by a higher courts, not the family court. Also, I want to read, our highest courts has also recognized that parents has a fundamental liberty interest protected by the 14th Amendment in making decisions regarding the care, custody, and control of a parent's child. Before a parent can be deprived of these parental rights, the parent is entitled to due process of law, which is troxel. Undoubtedly, a parent has a constitutional recognized fundamental right in a parental relationship with his or her child. I have all these in my lawsuit. I had studied all of these. The last thing I'm going to say, when the state steps in to end a relationship between a parent and a child, it must do so by following procedures that fully comply with the protections guaranteed by the Due Process Clause. No attorney is going to do this because they will lose their license. They don't want to fight this battle. Why? Because they will lose money. Attorneys want us in court forever. So this is what you have to start doing, is learning this stuff. Stand up. Learn cases in your state. Find the connection between all the GALs, judges, therapists, attorneys, psychologists. Everybody is involved. All right, that's my 2 for thought today. Have a great day. Bye.